Now, Pascal was speaking about enhancing cooperation among member states, but he also mentioned there has always been competition, tax competition, where member states were competing not only for investments and jobs, but also for tax bases, just trying to move away taxable base from other countries. And one key instrument for that in the past were tax rulings, and we were very happy to have today with us a representative from the European Commission, from DG Competition, is Gert Koopman. Gert Koopman is the Deputy Director General State Aid for the European Commission's DG for Competition, and he is responsible for the Commission's control of state aid and the coordination in about 1,000 state aid cases. And he is, I understand, also in particular in charge of the investigation of the European Commission into tax rulings. Tax rulings are very much criticized in the media, in the European Parliament, as being an evil instrument. I think per se tax rulings are of course not evil. I think they are necessary to provide in many cases legal certainty, but of course there were cases where countries use tax rulings to hand out benefits on a probably discretionary basis. I think this is an extremely important topic that is going to keep us as advisors and our clients extremely worried over the next couple of years, because if a measure is deemed to be state aid, not notified state aid, actually the country that has provided this tax benefit is obliged to claim back the tax benefits that were unjustly given to a taxpayer. Mr. Koopman, we are looking forward to your presentation, and the floor is yours.
Well, thank you very much, and good morning to all of you. It's a real pleasure to be here today in this venerable setting of tax experts and interested stakeholders. I speak with some trepidation because obviously the control of state aid covers a much narrower agenda than the one we have just seen exposed by Pascal. And obviously in conducting our affairs we are not in the business of harmonizing or pursuing policy objectives as such. We are effectively controlling to the extent that the aid is found to be illegal, illegal state aid. So it's important to realize the context within which we are working. What I thought I could do is to talk a little bit about this legal background, which for some of you may be a bit new, and then to zoom in on some of the key issues we are looking at. I hope you'll understand that obviously, given that some of these cases are sub judice, I cannot say anything about the individual cases, and I will also have to be quite restrained in commenting on some of what we would call in competition speak theories of harm, because they are equally still under investigation. So what I'm going to provide you is a bit of a high-level snapshot of what we are doing to date. Now, as I said, I think it's important for you to understand the legal background, which is the first part of my speech. Then I'll go on to aggressive tax planning, which is a subset of issues that we're looking at, and then zoom in further on transfer pricing rulings. I obviously wholly concur with today's chairman that there's nothing wrong with rulings as such. They are crucial to provide legal certainty. What we're after is not rulings per se, but we're after issues that rulings may generate in terms of providing state aid. So if I can start by giving you a sense of the legal context in which we are working, I have to refer to the treaty on European Union, which laid down basic rules on competition, amongst which state aid control is a European particularity. It doesn't exist anywhere else in the world, but was introduced obviously at the time to ensure that states which were very powerful, even more powerful than they are today, I would say, given the lack of harmonization and integration, would not unduly distort the internal market. So it's all about level playing field. the basic state aid treaty article is 107, which lays down 4 conditions for the definition of state aid. And these are important because in our tax cases, the crucial question in the rulings cases is going to be, is it aid or not aid? So it's worth dwelling a little bit on it. The first is, are we looking at state resources? And, if so, is the granting of these state resources to a company imputable to the state? Secondly, there's the issue of selectivity. Are these are these resources granted to all companies in a similar situation, or are they only granted to some, in which case the measure is selective? Then thirdly, is there an advantage for the company at stake? If there's no advantage, there is no aid. And finally, the treaty limits the control of state aid to measures that affect or potentially affect trade across member states. So smaller measures within countries are not covered by our competences. Now, the treaty lays down the principle that state aid is forbidden unless it is justified by what we call a common interest objective, which is either an economic efficiency objective, such as the furtherance of research and development, for example, or an equity objective. And secondly, it needs to be proportionate. In other words, it needs to be limited to what is really necessary to reach the objective at hand. If those conditions are met, and it is for the Commission in its exclusive competence as state aid controller to lay down these rules, then the measure can be found compatible, in other words, justified. So these grounds are the main features for finding aid acceptable, otherwise aid is not allowed. Now, fiscal state aid is a subset of our rules in this field. And actually, contrary to what some believe, there is quite a long history now of state aid enforcement in fiscal aid. I think a landmark case that some of you may want to look at is a case dating back to 1973, Italy versus the Commission. And it's also worth recalling that the Commission, back in 1998, a long time ago, adopted a communication on state aid in the field of direct business taxation, which essentially described at the time instances and situations where features of the direct taxation system were liable to generate state aid. Now, it's a little bit out of date, obviously, given developments in the market and in member states' tax systems. And we will be updating our general notice on the notion of aid, so what is aid, what is not aid, still this year, and that will cover in a chapter also fiscal state aid. So that gives you a sense of the basic rules. Now, it's against this background that we launched tax rulings investigations in June 2014. They, I would say, were the fruit of the creation of a task force which I set up back in 2013 on the back of market information that was pointing to potential problems. Now, before I say more about that, I would like to zoom in a bit further into this question of selectivity. Remember, one of the 4 criteria for deciding whether there is aid in the first place, namely material selectivity, which is critical in tax rulings cases. So I think the first general point is that the measure would have to apply only to certain undertakings or a single undertaking within a member state for it to be selective. What is very important, and this is a very different type of perspective from the one Pascal was talking about earlier today, is that the comparison we make under state aid law is within a member state. So in essence, we are not legally in the position to even look at the tax systems in other member states. The deviations from the norm, in other words, the potential selectivity, is always in respect of the national rules. So are member states using their tax system to favor certain companies? That's very important. So comparison within one member state. The courts have also consistently found that this selectivity need not be a de jure selectivity, in other words, laid down in law. It could also be de facto, in other words, if the consequences of the legislation are such that only a very limited number of companies benefit from a measure, even if at face value the measure would apply to all companies, then it would be selective de facto. In terms of our analysis, the way we go about this is that we first try to identify the reference system, in other words, the relevant tax system in the member state at hand, in most cases here the corporate tax system. We then try to assess whether there is a derogation from that reference system, in other words, whether there are benefits accruing to a certain group through a derogation laid down in law. And if a derogation is found, then there is a third step in the analysis, namely whether there is a justification in the tax system, in terms of the logic of the tax system, that would justify this deviation, in which case it would not be selective. An example for which is relevant is administrative manageability. You can well imagine that, for example, for very small taxpayers, SMEs, the rules would be slightly different simply because the administrative cost, the fixed cost of raising revenues would be very different for this category of undertaking. So the third test is also important and further narrows the scope of the material selectivity concept. Now, enough about the law. I think I'm now going to present two slides which I'd like to circumscribe very carefully. They are contextual information. This has got nothing to do with our investigations, but nevertheless they are interesting, I think, as a background. What these slides show, and you probably know this, is essentially the difference between statutory and effective tax rates. And you see on this slide, of course, that for a number of EU member states, the differences between the statutory tax rate, in other words, the tax rates you find in the law, and the effective tax rates, which have been calculated here as, the tax take divided by the tax base, can be very significant. And they seem to be very significant they seem to be significantly more significant for some member states as compared to other member states, notably Luxembourg, Ireland, and the Netherlands. Now, of course, that doesn't necessarily mean there is selectivity, but it does mean that some tax payers pay significantly less tax than other taxpayers. So in that sense, it's a sort of macro, prima facie, global indication that there might be an issue in terms of selectivity. But it's not more than that. Now, another way of looking at this is to look at the profits of foreign subsidiaries of US companies in the world. I always show this slide because when I first saw it, I told my staff to go away and fix it, because I thought it could not be correct, this slide. But it is somehow, at face value, surprising. These are all US companies, foreign subsidiaries globally, and we look at their profits, where they are actually registered. And it is a bit surprising, despite the fact that as a Dutchman, of course, I believe the Netherlands is a very, very important member state, but still, its size in the world economy would not immediately justify such a high tax take, and the same is true for some other relatively small member states like Luxembourg and Ireland. So again, this doesn't prove anything in terms of there being a problem, but contextually it is, I think, interesting information. Now, what we have started doing since the summer of 2013 builds on what I would say a fairly rich tradition, which I think was initiated in this field by Professor Monti when he was a Commissioner for Competition and for Taxation now nearly some 20 years ago. As you know, in the context of the Code of Conduct Group, which was then called the Primarolo Group, he essentially from both angles, so the tax angle and the competition angle, looked at harmful tax competition and opened back in 2001 15 investigations. These were investigations not only on tax rulings, but essentially on tax rulings and tax schemes that were quite similar to tax rulings in terms of their effects. Now, at the time, the main concern related to what loosely is called coordination centers, which essentially at the time allowed multinationals, afforded them special conditions in determining their tax liabilities. And they were found in many cases to be selective. In other words, selective in the sense that they granted advantages just to multinationals, so they were selective. And the Commission at the time took a number of negative decisions, some of which are quoted here on this slide. So this was not particularly new. The problems at the time were a bit different. As I said, we were looking mostly into coordination center type structures. And member states since then adjusted through the work of the Code of Conduct group and following some of our decisions, adjusted many of these systems. And then the issue actually disappeared a little bit from our radar screen in terms of tax rulings being problematic from a state aid point of view, until back in the early 2010s, media reports, market information about aggressive tax planning suggested that the world had adjusted to this new setting, the decisions taken earlier on, and that tax rulings were being used amongst other tools to facilitate aggressive tax planning. You know some of these reports which trickled out in 2012 and which triggered subsequently a debate in the US Senate, the UK House of Commons, which generated quite a lot of information, generated a lot of market information, a lot of correspondence with the Commission, and on that basis, when we started looking at it again, prima facie, there were a number of issues which we felt merited further assessment from a state aid point of view. That was also more or less the time when the BEPS project got underway. Now I don't want to say anything about that, given that we've just listened to a very good presentation of the issues, but obviously it touched on the same issues at a global level. Now, from a state aid point of view, as I've said, we have a very narrow perspective, a legal perspective, which also means that when we look at these issues, we have to judge every case on its own merits. There is no such thing as taking issue with a rulings practice per se. It all depends on the particularities of the case. And then when we decide actually to take formal action, to open a formal legal case, then it's exclusively facts-based. It's without prejudice when we open to the final outcome. Due process and the protection of confidentiality are crucial elements. And whilst, of course, this is often seen as part of the wider fight, against tax evasion, I have to underline very strongly that we are operating, the Commission is operating in a quasi-judicial setting here, and that there are Chinese walls between what we do here and other parts of the House, simply because these proceedings are confidential. So in that sense, it's a much narrower activity. Now, I think you probably know that we launched 4 formal cases, so these are actually formal cases where the Commission took action, where we expressed serious doubts about the arrangements. In 2014, in the summer of last year, we opened against Ireland, the Netherlands, Luxembourg, on 4 individual cases concerning rulings given to Apple, Starbucks, Fiat, and Amazon. Of course, in doing so, we underlined that it was not so much the rulings as such that were problematic, but what was in the rulings, which at face value, prima facie, gave us sufficient reason to doubt that there might be illegal state aid involved. Now, these proceedings have led to the publication of our concerns, our open decision, on which stakeholders and the member states and of course the companies themselves have been given an opportunity to comment. This is the way state aid proceedings work. These comments are now being assessed, and on that basis the Commission will then take a final decision which is binding and which is only subject to review by the European courts in Luxembourg. As you know, and as my Commissioner has clarified, we aim at taking decisions over the next months, so broadly speaking in the summer. So we're approaching the end of our work in this field. I should add that earlier this year, we also initiated proceedings, opened a formal case against a tax scheme in Belgium that uses rulings called the Belgian excess profit scheme, which we found at least merited further investigations because we had doubts about the selective nature of the arrangements. So these are very significant cases dealing with a problem that has evolved. This is not about coordination centers, this is about rulings, and I'll say now a bit more about the issues we are looking at. Now, the first issue is transfer pricing in profit shifting, where essentially the courts have found that state aid might be involved if in a controlled transaction, so between two parties belonging to the same group, different rules apply as compared to an uncontrolled transaction between two unrelated market parties. In other words, what is important here is that the courts have clarified that there should be the equivalent of a market price. Now, I'm not quite sure how I manipulate this, but in essence, what I think the right-hand part of this slide would show is that, in essence, there is, in some of our cases, prima facie evidence that profits are being shifted from a high-tax environment to a low-tax environment through inflated transfer pricing. In some cases, profits are being shifted, we think, from a low-tax environment to a zero-tax environment. And obviously, as compared to the left-hand part of this graph, where we're looking at uncontrolled transactions, that would pose a state aid problem. So we're looking into this. This is one issue that is relevant to the cases. It actually works. So you see the shift from a high taxation country to a low taxation country, leading to difficulties in this respect. And as I said, in some cases, we rather see shifts from a low taxation country to a no taxation country. Now, a second issue that is relevant is slightly different, concerns moving active income from economic activities through royalties and interest payments through a transfer pricing arrangement to a country that could be qualified as a tax haven, where essentially the profits are being transferred out to this country through, and this is blessed through a tax ruling with a little tax stake in the middle. Again, the question is, is this part of the normal tax system in the country, or is a selective advantage being granted through the tax ruling to this company benefiting from the ruling? So these are just two illustrations of the sort of issues that come up. Now, as I've said, our focus is a narrow focus. We have to prove the existence of state aid. First, the reference system, the corporate tax system. And then secondly, the question of whether a market price or something that relates to a market price is actually being charged. And that, in essence, is important because the arm's length principle is not just an OECD principle, but it's actually a principle of European law, as the courts have found. So just to take away a misunderstanding that seems to exist, we're not vetting whether countries or rulings comply with the OECD transfer pricing guidelines as such. That would be an awkward activity for the Commission to engage in. What we're actually doing is simply looking at whether the arm's length principle as such is laid down sufficiently in the national law or is being implemented in an acceptable manner in the ruling at hand. So this is a slightly different take, and it's based on court jurisprudence, not on the OECD guidelines. Now, I don't want to take, as I said, it's far too early to draw any conclusions, but there are some, I think, takeaway points which are significant. I mean, the first is that, from a state aid point of view, tax administrations must verify that transfer pricing actually mirrors market terms to which an unrelated party would have had access. And I think that's really a very fundamental point. There is a duty on the tax authorities to actively verify this. It's not something that can be taken lightly, because otherwise this this principle from the courts is not respected. Now, of course, the OECD transfer pricing guidelines can help in doing that. Member states can avail themselves, but it is also important that if that happens, and if that is the basis for the discussion, that is looked at very carefully, and that the tax authorities should check whether the market, whether the result corresponds with the market result. So this is not just a matter of taking note of the fact that there is a report by a consultancy or by one of the four big accountancy firms. This is something where there is an active duty of responsibility for the tax authorities. I'm afraid I can't say very much more, but this is where we are. Decisions will follow in the coming months. They will provide, I think, some clarity as to how we appreciate this from a state aid point of view. Colleagues probably know that we have, meanwhile, also asked information from all other member states. We're looking at a number of cases and issues that come out from that, and obviously on that basis we will take further action as and when necessary. So it is too early today to draw any conclusions from just 4 cases which are still sub judice. As I said, there are other cases we're looking at, and I think it will be much more interesting to try to see whether there are any general lessons to be drawn from this exercise in the summer of next year rather than today. Thank you very much.
Thank you. Thank you very much, Mr. Koopman. And I'm sure there would be quite a number of questions and issues, but in the interest of time, and I think because the next panel is anyway going to be supposed to discuss how is this going to impact the activities of companies, what is going to be the impact on the real world, as we call it. I think we can leave probably those questions to be raised by and discussed by the panel. Thank you very much. And I would like now ask the panelists and the chair of the next panel, Mrs. Frances Robinson, to join me here on the stage.